had liquor to the child, and there is a problem, and the child refuses to pay for the drink, you cannot send that child to the court because he's a minor. And you cannot force him to pay you. So that is why I'm saying that you cannot force the child or the minor to pay you for, because you know he's a minor, unless you prove you are not aware that he's a minor. Though we have some other instances where a minor may at times be allowed to enter into a contract. In law, we have a lot of exceptions. Every rule has an exception. And the exception in this case of a minor is where what you are selling to the child is of necessity to the child, to sustain the child. Then in that case, then the child can enter into an agreement. And don't forget, buying and selling is a contract. Buying and selling is a contract. So a child who approaches you with money to buy Fanta or Coke, you can sell to that child. You are entering into a contract with a child. It's allowed because it saves his life. It's a necessity of life, so you can do that. But you cannot sell alcohol to that child. If you sell it, the child can refuse to pay, and you cannot do anything about it. But a Fanta, the child must pay because it's of necessity to. So we have two types of entering into a contract with a child. One you can't, the other you can, where it is of a necessity to the child. So if a child comes to buy an expensive car from your shop, believing that you pay, and you sell the car, the child can refuse to pay. You cannot do anything about it. Why? Because it's expensive, it's not of a necessity to the child, it's not reasonably necessity to the child, so you cannot that one. So you cannot enforce the contract against the child. So it's the difference between that. Somebody who is alcoholic or drunkard, you cannot make a contract with a drunkard for the mere fact that the person was not in the correct sense to really debate and discuss issues and come to a conclusion on the contract. In that case, we are talking about the moment of signing the contract with the drunkard. At the time you were signing the contract with the drunkard, what was his situation? Was he drunk? Were you aware he was drunk before you signed it? These are the questions. And being drunk is not only something smelling, or you drink and the smell, you can sense it. It could be a drug, but the person is not sane, is insane to really know what he's doing. And a mad person too, you are not only talking or really talking about somebody who is naked on the street, very mad. No, just somebody who is not in the correct sense of mind. It could be somebody under distress. It could be somebody who was not in the good frame of mind, we can say is mad, not the person on the street naked, no. Somebody can dress very well, in suit, but he's mad. His action, everything is mad, it's not correct. And this can be determined by the medical report that can be issued, that the person at the time of signing the agreement, what was his state? Mad or not mad? And when he was mad, were you aware? What is your defense? Your defense is he was okay. But at times the amount of money you pay for the house the madman was selling to you could determine whether you were aware or not. If he's selling his whole house to you at the time he was mad for 10,000 Ghana cedis, and you pay that, and the man now being correct, because don't forget we have periodic madness. People get mad, then later they can become okay after some time, and he wants to collect his house back. So the price given can determine whether you were aware he was mad at the time of signing or not. So we have different scenarios and different cases concerning incapacity. The incapacity can generally vitiate a contract. Now, duress. Duress, it is actual or threatened physical violence to unlawful constraint of a contracting party, which will suffice for the purpose. it is available to nullify the consent and thereby nullify the contract where there has been coercion of will. At the beginning, we said contract must be entered free willingly by everybody. The law allows anybody, provided you have capacity, to enter into any type of contract which is not prohibited or which is not illegal. So there is a freedom of entering into a contract. And so nobody should be forced to make a contract. And once you have willingly accepted to enter into contract with another person, even including married contracts, it means that person has consciously entered into the contract, and therefore there is no force. If there is force, the other party can refuse any obligation under the contract. That is why contracts must be entered free willingly by everybody. So it must be established whether the person relying on the plea had acted voluntarily or not, by considering whether the person alleged to have been coerced did or did not protest. So what have you done or contributed to the coercion to enter into such an agreement? And forcing you into agreement could be in different forms. Somebody can hold a gun or knife on you, that if you don't sign this agreement, I'll kill you. It's coercion. Or threaten to withdraw your salary if you don't agree to the contract. If you don't sign it, I'll not pay you again your salary. It's a coercion. Or I'll seize your property, or anything which is a threat. So it could not be direct threat like killing you, but there are different forms of threat. Or any act that makes you enter into a contract without free will. It's not from you free will, but something forces you into it. Then we say it's a duress, physical threat. So a contract has all these duress. It must actually exist at the time of making the contract. At the time of making the contract. So duress will not be acceptable in a contract. We have also undue influence. Undue influence is just similar to duress. But this one, undue influence, there is no coercion. There is no physical force. There is no physical force, but an influence. And the influence connotes the power to affect another's character. Influenced by your power, by virtue of your position, you influence another to enter into a contract. Or his belief or action through admiration, exceptional fiduciary relationship, fear, and the rest. So this one is not really a force, but a fear of authority. A fear of authority. By virtue of position, you fear and you enter into a contract with another person. So influence is undue if it is improper or more than is right. So undue influence is an equitable defense to avoid a contract where the relationship between the contracting parties is such that one party, being the dominant party, will presumably or in fact have taken advantage of his dominant position over the subservient party. Whereas duress deals with the coercion of the will, notably threats and force. Undue influence deals with the improper manipulation of a contracting party. So in duress, there is a threat of force or force itself. Force is really a physical use of violence so that you can take the contract. And influence is by just manipulation of your position or a power that you had over the other person. So there are two opinions available when undue influence is detected. And when we talk about undue influence, we are talking about a relationship between two people which may influence the contract. For example, you imagine a contract between a patient and his medical doctor, a teacher and his students, a lecturer and his students, a client and maybe a lawyer, a congregation and a pastor, or member of a church and the pastor. You imagine the two are making an agreement. So there is one that is superior and the other one who is really, we can say, is subservient party. Because of respect or fear of the authority, he or she may quickly accept the contract. But there must be a direct relationship between the two. Parents and a child, a parent and a ward making an agreement. So one is higher than the other so far as respect and influence is considered. So you realize that undue influence could be only between two parties that are not of the same authority, and therefore one is afraid and may enter into a contract because of the fear or respect for the authority that is between the two of them.